Thank you so much for the kind introduction and the warm welcome. It's truly a great honor and pleasure to be here, and it's wonderful to be able to do the program with my favorite collaborator and favorite co-author. No democracy lasts forever. Democracies are there until they're not. We're all familiar with countries in the world that once were democracies but no longer are. It would just be hubris to believe that the United States is somehow immune from the pressures that caused other democracies to collapse. I've never been so afraid, never could imagine being so afraid for the future of American democracy as I am right now. What we've seen since January 20th is unprecedented in American history. We've never had a president so frequently violate the laws and Constitution of the United States as we've seen over the last 8 months. Think of President Trump's executive order to restrict birthright citizenship in clear violation of the 14th Amendment, or President Trump's use of military troops in Los Angeles, now in Portland and Chicago, in clear violation of the Posse Comitatus Act, in violation of a long tradition against using the military for domestic law enforcement purposes. Or President Trump eliminating entire agencies, USAID, the Department of Education, that were created by Congress, that only Congress can eliminate. We've never seen a president try to so greatly expand presidential powers at the expense of the authority of the other branches of government. President Trump has claimed the authority to fire agency heads, notwithstanding federal statutes limiting removal. He's claimed the authority to fire anyone, notwithstanding civil service protection, who's employed in the federal branch of government. He's impounded enormous sums of money appropriated by federal statute, even though there's no authority under the Constitution to do that. We've never seen a president before so overtly use power for retribution. Think of his attempt to put some law firms literally out of business. The first law firm he targeted was Perkins Coie. What was their offense? They represented Hillary Clinton in 2016. Other law firms were targeted simply because they employed Robert Mueller or members of his staff. We saw just 10 days ago that he orchestrated the indictment of James Comey openly for the purpose of retribution. We've seen him pursuing criminal investigations against Adam Schiff, Letitia James, John Bolton, and others, again, entirely for purposes of retribution. So this is the context for our conversation tonight. We decided to focus in depth on two topics. Catherine, who's an expert on labor and employment law, wants to talk about what the Trump administration is doing with regard to the federal workforce. And then I want to talk about what the Trump administration is doing to universities in this country. Catherine will then conclude with a few thoughts, and then we're glad to take your questions for the remaining 20 minutes.
So thank you so much for having us here. I've never had such a deep appreciation for the federal civil service as I have now, watching them stand up for good government against tremendous pressure. And I say that having once been a federal civil servant, and my mother was a federal civil servant. From before President Trump was elected for his second term, it was clear that the plan of the Republican Party to seize control of government by consolidating power in the White House was going to involve trying to eliminate a principle that's been in American law for 150 years, that employment in the civilian federal service is based on merit, and that discipline, promotion, discharge must follow a process that gives employees the opportunity to demonstrate that they remain entitled to and able to perform their jobs, and that the the decisions can't be based on political considerations. As you all know, the Trump administration's attack on the civil service has come from many directions. The most important overarching theme is an effort to consolidate all power over hiring, promotion, and firing in the White House. This is contrary to the current law, the Civil Service Reform Act of 1978, which was enacted in the wake of the Watergate scandal, to try to insulate the federal workforce from political pressure. But the law's older than that. As I said, it's been in force in one form or another since 1883, when Congress enacted the Pendleton Act after it had become abundantly clear, both in the period leading up to the Civil War and thereafter, that hiring, promotion, and firing of federal employees based on their political support of the president in power was a disaster for the quality of the government, including the conduct of the Civil War. The expansion of protections for federal employees after 1883, one of the major ones, was a statute enacted in 1939 known as the Hatch Act. The Hatch Act was actually pushed by Republicans who were concerned that the large number of people who went to work for the federal government during the New Deal tended to be college-educated liberals and hostile to the conservative wing of the Democratic Party and the conservative wing of the Republican Party. And the Hatch Act prohibits political considerations in hiring, in any job activity, and prohibits a great deal of political activity by federal employees. The Trump administration has been disregarding all of this law in more ways than I could possibly enumerate. Firing Justice Department lawyers, such as former FBI Director James Comey's daughter, Maureen, a respected federal prosecutor in New York, was fired for no reason other than, no reason was stated, but anecdotally, it was conveyed that it was because her father was one of Donald Trump's political enemies. They also fired most federal prosecutors who worked on cases involving the riot or insurrection on January 6th. They fired FBI agents who were involved in investigating the events of January 6th. They've fired federal prosecutors who truthfully admitted, for example, in the case of Erez Ruveni, to a federal judge in response to a question that Kilmar Albrego Garcia was deported from the United States in violation of a court order prohibiting his removal in error. When he answered the question of yes, it was a mistake, he was fired for being truthful to the federal judge, even though the rules of professional conduct applicable to all lawyers, including federal immigration prosecutors, require that we be truthful. And so why are they doing this? Well, they're trying to consolidate power over the civil service because they recognize that the civil service are responsible for implementing laws, including laws enacted by past Congresses, signed by past presidents, whom the current president, or which the current president does not support. Environmental laws, civil rights laws. They don't have the votes to repeal that legislation, but if they can fire every federal worker who enforces it, then it's as good as eliminating the legislation. It's for that reason, as Erwin said a few minutes ago, that they have fired the heads of independent agencies, including the National Labor Relations Board, the Federal Trade Commission, a variety of agencies that enforce federal laws, for the purpose of either intimidating those who remain, or shutting down the agency entirely. That's how they've managed to shut down many functions of the U.S. Department of Education, the Consumer Financial Protection Bureau, which, as its name suggests, protects consumers in financial matters, and the National Labor Relations Board, which has been defunct since January 27th, 2025, when the president fired the first black female person to serve as a member of the NLRB. And the NLRB is currently down to one member, which means it can't do anything. And so all of this is not just an effort to sway those who remain or to prevent the enforcement of particular laws. It's to enable Congress's legislation to be completely eliminated as a practical matter and to remove any obstacles to the White House doing whatever it wants. That's been especially important, as we've seen, as the White House has done all kinds of things that would never have been approved by the lawyers in the Department of Justice, whose job it is to opine on the legality of executive branch actions. If those lawyers were on the job, the government wouldn't be able to do what it's trying to do, or it would face much more pushback against deploying National Guard in blue cities or deporting people to countries where they have no connection and without the rudiments of due process. And so the thing that I think we should all be thinking about is what the values are of having a nonpartisan civil service. And this is what I want to wrap up with. There is a lot of empirical study of the benefit of having a government workforce that is not identified, with any particular party. They can, of course, vote as their conscience dictates, but they don't come in when there is a new party in control. They don't leave when the White House switches hands. Why do many countries, most with high records on the rule of law, strong economies, insist on a nonpartisan civil service? Why does a majority of states insist on a nonpartisan civil service? It's because the overwhelming number of empirical studies of the effect of having civil servants hired only on the basis of merit and fired only on the basis of misconduct is to increase the performance of government on any measure you can think of good government. The effectiveness of programs, confidence of people in the quality of the delivery of federal service, whatever the service it is, whether it's the IRS or the Social Security Administration or food inspection or anything else. Any measure of good government improves when the workforce that implements governance is hired and promoted based on merit. The evidence also shows that better quality applicants will apply for government jobs when they expect to be able to stay in their job instead of having to leave in 4 years if the party in power loses office. And conversely, when hiring and firing for government jobs is based on political loyalty to the party in power, the one thing you do see is an increase in corruption. And you probably noticed that there are all sorts of bits of evidence that the amount of corruption is increasing. For example, people who've been convicted of crimes, especially big financial crimes, are now trying to identify connections to the Trump administration so that they could get pardoned or have their sentence commuted. Or people who want to do business with the government are making substantial investments in cryptocurrency enterprises controlled by the Trump family. And so what we see from all of this is that scholars of public administration, economists, political scientists, both in the US and globally, and this has been studied in the US, federally, state level, and all over the world, show that a nonpartisan civil service is not only consistent with the democratic values that we identify, but also is more likely to lead to better quality government. One of the things that I think has been quite interesting in the pushback against the Trump administration's effort to take control over the federal service is how many federal judges, whether they were appointed by Republican presidents, including Donald Trump in his first term, or Democratic presidents, have ruled that the Trump administration's firing of Justice Department lawyers or probationary employees or what have you violate a whole range of laws, including the ones I mentioned earlier, the Civil Service Reform Act, as well as other more obscure laws like the Administrative Procedure Act. The Trump administration has been losing all these cases in the trial court. The Supreme Court has been staying those opinions temporarily without formally ruling on the merits. And I think one of the things to watch as time goes on is what the Supreme Court does about that. But I'm not the Supreme Court watcher in my household or on my faculty. I'm sitting next to the one. So Erwin, what do you think?
There are many issues for us possibly to talk about, and Catherine was going to focus on employment. I can certainly give you my worries about what the Supreme Court's going to do. To answer the question that you posed to me, so far the district courts across the country, as you say, both with Republican and Democratic appointees, have struck down literally hundreds of Trump actions. The courts of appeals have overwhelmingly upheld what the district courts have done, but the Supreme Court, in almost every case, has reversed the lower courts and ruled in favor of the Trump administration. Now, almost all of these have been on the Supreme Court's emergency docket so far, the shadow docket, so they're not decisions on the merits, they're not following briefing and oral argument, but I worry that they are a precursor to the Supreme Court, especially in the area of appointments and removal, including civil service, saying it's a unitary executive, the president is in charge, the president can fire anyone, any statute to the contrary is unconstitutional. But we'll see in some cases that are going to be heard in the Supreme Court in November and then in January about that. I wanted to focus on a different issue that we can certainly come back and talk about this one. I wanted to focus on the attack on American universities. What we've seen since January 20th is the most blatant effort to just inflict harm on universities that's ever been witnessed in this country. And to me, it's perplexing as to why a president would want to do this. We have the greatest university system in the world. Why would someone want to harm it? Why would someone want to give an advantage to some country like China as it builds its university system? Why would anyone want to cut medical research in the way that we've seen since January 20th? I'll talk about a case that I'm involved in. Some of our named plaintiffs are involved in researching about drug-resistant tuberculosis, about developing better MRI machines, about dealing with the health effects of wildfire smoke on lungs, about finding better cures for pancreatic cancer. Who is served by cutting back on that medical research? And yet each of the instances I just mentioned are about people who had grants that were cut off since January 20th. Perhaps it's that President Trump just regards universities as a bastion of liberalism and is going after them for that reason. Or perhaps he's following the same playbook that authoritarians have used throughout the world of coming to power in part by going after universities. Look at what Viktor Orban did in Hungary and how similar it is to what Donald Trump is doing here. What Donald Trump and his administration have figured out is that American universities have three financial vulnerabilities. First, they are all very dependent on federal research money, and this is particularly so of elite universities. Second, they are very dependent on foreign students and the tuition that they come and pay. And third, and especially for elite universities, they're very dependent on philanthropy. And it's important to note that the Trump administration, and with regard to the latter, Congress, have gone after each of them in a major way. Let me focus especially on the first, but say a little about the latter two as well. We've all witnessed the Trump administration cutting off money to elite universities. It started with cutting off $400 million to Columbia University. Then it was cutting off $2 billion to Harvard University, then declaring that Harvard University can't receive any new federal grants. It was also saying that no foreign students can go to Harvard, knowing that 27% of the student population at Harvard are international students. Then it was going after the University of Pennsylvania, because at one point it allowed a transgender woman on its swim team. Then it was going after Brown, Cornell, and Northwestern. On August 1st, the Trump administration cut off $584 million of aid to UCLA. This is aid directed at particular universities. It doesn't include all of the cuts in federal grants that have affected researchers at universities. As of June 1st, according to the Department of Government Efficiency's own website, University of California researchers had $324 million cut off. We now know that this was incomplete. It didn't include a great many of the grants, didn't include sub-grants. So my guess is by June 1st, $750 million in grants to University of California researchers had been cut off. What I want to say to you tonight is that this was blatantly illegal. Now, the Trump administration has said it was doing this because of anti-Semitism on campus and the failure of universities to adequately deal with it. I, of course, do not deny that there's been anti-Semitism on campus, but that does not make what the Trump administration has done in cutting off funds lawful. The federal statute involved here is Title VI of the 1964 Civil Rights Act. It says that recipients of federal funds cannot discriminate based on race or ethnicity, and specifically the legal standard is they can't be deliberately indifferent to racism or anti-Semitism that would be on their campuses. Federal law is clear that if the government wants to cut off funds to a university for violating Title VI, it has to follow specific procedures. It has to give notice to the university of the charges against it. There has to be a hearing in front of an impartial decision maker. There have to be findings of fact that the recipient of federal funds, the university, violated federal law. Federal statute is clear that before any money can cut off, there has to be 30 days advance notice to both the Senate and the House of Representatives. If money is cut off, it can only be to the part of the program that itself is found to violate federal law. The Trump administration followed none of those procedures. That makes the cutoff of money to all of these universities illegal for failure to follow the law. But it's illegal for other reasons as well. There's a federal statute, the Impoundment Control Act of 1974, that says that the president cannot refuse to spend money appropriated by Congress. Additionally, much of the money that's been cut off has been in violation of the First Amendment. It's been based on the viewpoint expressed. The core of the First Amendment is that the government can never punish speech, deny benefits for speech because of the viewpoint expressed. What the Trump administration did was do a word search of grants, and any grant that had the word diversity in it then was cut off. So in the case that I'm involved in, one of our plaintiffs was doing work about plant diversity. Grant was cut off. Another was doing research on the diversity of microbiomes in the stomach. Grant was cut off. The fact that they were cutting off grants just because of the word diversity is about viewpoint discrimination. It also violates federal statutes that empowered the agencies, indeed required the agencies, to pursue diversity. There's also a federal law that says that the government can't act in a manner that's arbitrary, capricious, or abuse of discretion. The Trump administration cut off grants without any explanation. And the Supreme Court has said it violates that statute unless a decision is reasonable and reasonably explained. One of the sad things to me so far is that almost no universities that have money cut back have filed lawsuits challenging this in court. Harvard is the only university that I can identify that's had money cut off, and it's gone to federal court to bring a challenge against this. And so far, it's won. You might note that a few weeks ago, a federal judge in Boston, Allison Burroughs, found that the cutoff of money to Harvard violated the First Amendment. She said, just what I did to you now, it was viewpoint discrimination in violation of the Constitution. She ordered all the money cut off to Harvard be restored. She earlier had found that preventing Harvard from being international students was, in the words of the statute I quoted, arbitrary, capricious, and an abuse of discretion. I'm tremendously dismayed that the University of California has not filed a lawsuit to challenge the cutoff of funds to researchers or the cutoff of funds to UCLA. A group of volunteer pro bono lawyers have brought a lawsuit on behalf of the faculty and researchers. They're not representing the University of California, but they're representing the faculty and researchers. I'm proud to be one of those lawyers. One of my colleagues on the faculty is another, and two law firms in San Francisco, Leaf Cabraser and Farella Brown, are doing this pro bono. We filed a lawsuit at the beginning of June claiming that the cutoff of funds to UC researchers was a violation of the First Amendment and arbitrary, capricious abuse of discretion. On June 23rd, the federal district court in San Francisco ruled in our favor. She focused on the three agencies that named plaintiffs in the complaint had received grants from: the National Endowment, the National Science Foundation, the National Endowment for Humanities, and the Environmental Protection Agency, and ordered all of the money to UC researchers from these agencies be restored. On August 21st, the Ninth Circuit upheld her ruling. After the Trump administration cut off the money to UCLA, we went to court and asked for contempt. And on August 12th, the judge found that the cutoff of $86 million of National Science Foundation money violated her early order and that it had to be restored. We then went to court to expand our lawsuit to include the grants from the National Institutes of Health, as well as the grants from the Department of Defense and Department of Transportation. And 2 weeks ago, the judge ruled in our favor on that and ordered over $500 million of NIH grants be restored to UC faculty and researchers. Well, thank you. And I mean, obviously, there's a long way to go in this, but my concern is, why is it a couple of law professors and two law firms pro bono doing this? Why hasn't the University of California brought the lawsuit? Why have so many of the universities just capitulated? I'm sure you read that rather than sue the Trump administration, Columbia University has agreed to settle for $221 million being paid to the federal government. Brown University agreed to pay $50 million to provide for community services, but part of the settlement is that Brown will no longer provide gender-affirming care at any Brown medical facilities, and that Brown will adhere to the Trump administration definitions with regard to gender. That has nothing to do with violating Title VI. This is all about the Trump administration using federal funds to extort universities to adhere to its own agenda. I said that the government has recognized three vulnerabilities of universities. One is the dependence on federal funds that I've talked some about. The second is the dependence on foreign students. I'll talk about my law school. We have an advanced law program that's almost exclusively foreign students. This past spring, our wonderful provost, Ben Hermelin, said to me, "What happens if you can't get those students this year? What's your contingency plan?" I said, "That's $20 million of our budget. I don't have a contingency plan for $20 million. The Trump administration created a suspension of visa processing and has made it much harder for foreign students to get visas. I worry going forward that foreign students will go elsewhere in the world for their education rather than come to the United States. It's a great financial harm to American universities, but it's also a harm to the education of our students. Our students benefit from hearing the experience of foreign students. I'm teaching criminal procedure this semester, and it's about policing. And I have foreign students in this advanced program in my class. When my students get to hear about policing in foreign countries, they learn something that otherwise would be absent. And now the Trump administration has said that for H-1B visas, it's going to be a $100,000 fee. That will also very much discourage talented foreign students from coming to the United States. And a final dependence of American universities is on philanthropy. And it didn't get very much attention, but one of the things that the bill that was signed by President Trump this summer did was impose a tax on endowments, especially for the most elite universities. And that money has to come from someplace. So all of these are efforts to harm universities and often harm students in the process. One of the things that that large bill did this summer was put a cap on student borrowing. So for law school, the new cap is going to be $50,000 a year. Our tuition this year for in-state students is $65,000. For out-of-state students is $79,000. That's what's true of all of elite law schools now, public or private. But the cap on loans is $50,000. Are students going to need to go to the private loan market and get undesirable terms? Or will some with poor credit not even get loans? Will law school now be only for those rich enough to afford this very large tuition? As I say, I think this is something that didn't get much publicity. I want to conclude talking about the assault on universities with something from just last week. On Wednesday night, October 1st, the Trump administration sent letters to 9 major universities proposing that they agree to a compact. The letter said that if they'll agree to the terms the Trump administration proposes, they'll be able to get federal money, they'll be able to have a desirable rate of return that they're able to charge on federal grants. And it concludes by saying that any university that wants to have different values than this can do without federal money. Remember, no university can do without federal money right now. The terms in this compact are blatantly unconstitutional, they're undesirable, and they're harmful to students. One of the provisions in the letter says that the university agrees that it will punish anyone, and I'm quoting, who belittles conservatives' ideas. We're allowed to belittle any idea under the First Amendment, liberal or conservative. Does this mean that if a professor says something that's seen to be critical of a conservative idea, the whole university would lose its money? Another provision of this so-called compact would say that the university must require that all of its administrators and faculty in their official capacity, I'm quoting, not discuss any political or social issues. So if Catherine in class were to talk about what she did tonight, would that mean that the university can't receive the money? Can you imagine a more blatant violation of the First Amendment than this? Another provision says that by agreeing to the compact, the campus has to agree that it will adhere to the definitions of gender that the Trump administration has put forward. That includes not allowing transgender athletes, likely will include not allowing gender-neutral bathrooms, and the like. It would really be throwing transgender students under the bus. Another provision is going to undermine the quality of education for students. It says that any university who agrees to this compact can't increase tuition for the next 5 years, can't take more than 15% international students, and has to provide free STEM education if it's a school with an endowment over a certain level. Costs for university are increasing every year. if universities can't do things like increase tuition or take foreign students, they have no choice but to cut the quality of education for students. There is no other source of money that's out there. This would give the federal government unprecedented control over universities in the United States. If the Trump administration can demand this now, they can demand anything next time. I think it's so essential that every university say no to this. We all learned a long time ago on the playground that if you get into a bully, you only make it worse.
So let me just wrap up quickly and then open it up for questions. Some of you might be thinking about what is the effect of the current shutdown of the federal government on all of this? And the answer is, I think it's part of an effort to destroy the administration of, for example, federally funded research by furloughing employees who handle those grants. And it's an effort to enable the government to fire civil servants when they have not yet been able to do it through the various ways that I alluded to earlier. Russell Vogt, who's the head of the Office of Management and Budget, who is the architect of a lot of this, has announced in a way that he doesn't actually have authority, but he's issued 2 memos in the run-up to the shutdown, which began on midnight of September 30th at the end of the federal fiscal year, that agencies would retain on working without pay as emergency employees, and the only federal employees who can be required to work without pay under the federal law governing shutdowns of the federal government are those whose services are necessary for emergency services. And what he said is, the HR people who would administer the firing or the reduction in force, as they call it, of civil servants should stay working on the job for free because firing civil servants is an emergency. This is complete nonsense. Look, I just belittled a conservative idea. Or I made a statement of fact. There is no basis in the federal law governing federal shutdowns, and there's a whole federal statute regulating this that, by the way, was enacted and signed by Donald Trump in 2019 after the last federal shutdown. There's no way to declare people who would administer a reduction of force to be emergencies. That's for TSA employees, so planes can fly. It's for air traffic controllers, so planes can fly. It's for prison guards. That's who's supposed to be able to work without pay during a shutdown. But nevertheless, what they're trying to do is, by violating this law, they're hoping to get a sort of 2-part win. One, to consolidate the ability of the White House to declare which federal employees work under which circumstances, including without pay, without regard to the limits that Congress enacted 6 years ago and the president signed. And 2, they're trying to convince the public, Congress, and of course civil servants that the problem with the Democrats having resisted the continuing resolution because they want to protect Medicaid subsidies and the health care benefits that are going to be terminated in 2026 after the midterm elections under last summer's budget legislation. They're trying to convince people that Democrats can't resist the Trump administration no matter what. If they resist, the federal civil service will be decimated more than it already has been, or they can just go along with the Trump administration. What encourages me, and I can't end on a total bummer, is, as I said earlier, there is so much litigation that has been filed, as Erwin talked about, volunteer lawyers, Federal unions have been really at the forefront of trying to protect the civil service, including litigation challenging this new effort to use the shutdown to fire any employees that Russell Vought wants to fire. And I think that what that says to me, to sort of put on my hat as a labor lawyer, is that the power of collective resistance through law is really the only power that good-thinking people have left. But it's tremendous power, whether it's through litigation or through collective action, as unions are doing after they have lost the ability to collect union dues. They've been abolished by the Trump administration in his attack on the federal service. They haven't gone away. They're still fighting back. And so that's what encourages me going forward. So with that, let's have some questions. And I can't see very well, but how about gentleman in the back in the white shirt? Yes.
Yes. I seem to recall at the beginning of this second administration of Trump, the whole issue came up of some of their actions being illegal, potentially.
I'm going to answer the question as phrased as, what can we do? I'm also glad to answer separately what may be the underlying basis of the question. If the Trump administration violates court orders, what happens then? Should I address both of those or one of those? Both. You want me to? Let me do them in the reverse order of what I stated. The reason I do that is that if the Trump administration violates court orders, then there's nothing that can be done but impeachment and removal. That seems so unthinkable at this point that then what it would mean would be that the president can violate a court order and nothing can happen. And that would, and it's not hyperbole to say, be the end of the rule of law and constitutional democracy as we know it. Because if the president can violate a court order after infringing the Constitution, ignoring federal law, he then can do anything. Then the president could lock up me or you or any critic, and it doesn't matter if a court would order a release, he's able to do that. Now, there have been at least rhetoric from the president and vice president that it might happen. Donald Trump said, and I quote, "He who saves the country violates no law." J.D. Vance has said the president doesn't have to violate court orders that he believes infringes his power. I don't think any president in history has ever ignored Supreme Court orders. Many people quote Andrew Jackson as saying, John Marshall made his ruling, let him enforce it. Andrew Jackson never said that. It wasn't attributed to him 20 years after he died. Now, what can a court do with regard to enforcing orders? Well, there's the possibility of criminal contempt against anybody who violates a court order. But the problem with that is on July 1st, 2024, in Trump versus the United States, the Supreme Court said the president has absolute immunity from criminal liability for any official act in office. There's civil contempt. If somebody violates a court order, they can be put in jail or fined until they comply with it. But civil contempt is enforced by the United States Marshals. The United States Marshals are part of the United States Department of Justice under the command of Pam Bondi. That's why I said, if the president chooses to disobey the court orders, there's nothing that can be done but impeachment and removal. And if that doesn't happen, then the president can do whatever he wants. And I hope we never get to that point, but that we're having that conversation right now makes it very salient to recognize how much is at stake. What's at stake is our democracy as we've known it. What can we do? Well, let me suggest three things. First, we all need to be informed. I've heard too many people say that it's just too depressing to read the newspaper or listen to the news now. We can't afford that. And when we're informed, we have to inform others as well. Second, we have to get involved. There's many ways to get involved. There are so many organizations that are fighting back right now, whether it's ACLU or Track Democracy, Democracy Forward, and we have the obligation to find those organizations, to support them by being volunteers, to support them with financial assistance, to be involved in activities that occur where it's an opportunity to educate and inform people and to fight back. And finally, the third thing is we really have to find ways to speak out. It might be just as simple as writing to members of Congress and senators. They pay attention to that. It might be petitions. I think it has to be going to rallies and being in the streets and expressing ourselves. But democracy will die in silence, which is why I think one of the most important things we have to do is use our voices.
Yes, in the back. Yeah, yeah, yes, you.
The corrupt Supreme Court majority, at least three members are pretty obviously corrupt, has facilitated a lot.
So to change the composition of the Supreme Court requires legislation. That's not going to happen in Congress at the moment. What it really requires, though, is for Congress and the Supreme Court itself to be afraid of the delegitimation of the Supreme Court, of changed composition of the court. So remember back to, if you remember your New Deal history, in 1935-36, when the very conservative Supreme Court majority was declaring unconstitutional crucial aspects of the early New Deal. And President Franklin Roosevelt started talking about and proposed a plan to expand the size of the Supreme Court, the court packing plan. It was fairly unpopular as a policy proposal, but many people think it worked quite well as a threat to the Supreme Court to persuade ultimately one justice, whose name coincidentally was Roberts, to change his vote to start to uphold crucial pieces of New Deal legislation. But I actually think, although we do have a Supreme Court expert here, and again, I'm not it, I think one of the things that influenced the Supreme Court was not just the threat to expand the size of the court, but the fact that in the winter of 1936-37, there were massive sit-down strikes at major American manufacturing plants, a famous one at General Motors in Detroit or Dearborn, Flint, but many, many other companies across the country had sit-down strikes. There was a sit-down strike at the Woolworths in Detroit where the overwhelmingly female clerical cashier staff sat down. And there was so much uprising against the conservative Supreme Court, which was perceived as doing the work of a few or several large manufacturing companies, that the Flint sit-down strike started on December 30th, 1936. It ended in mid-February 1937. And in March 1937, the Supreme Court, Owen Roberts changed his vote in a crucial case, upheld the constitutionality of a piece of New Deal legislation. April 12th, 1937, the Supreme Court upheld the constitutionality of the National Labor Relations Act, which everybody thought was going to be declared unconstitutional. And so I think the threat for it to be a realistic threat to prompt the Supreme Court to behave differently is going to require a lot of activism of ordinary people like us, criticism by lots of people on a bipartisan basis. And I do think that would be a check on the Supreme Court because they care about their respectability. They care about their legacy. They don't want to be the justices who preside over the collapse of the rule of law and the end of the American Republic. And so intimidating them with the loss of legitimacy, I think even that would work with some in the Trump administration. Yes, Donald Trump himself would like to be king, but he is enabled by a whole throng of people around him who want legitimate power. They don't want to rule, I mean, some do, but many don't want to rule at the point of a bayonet. They want to actually rule with the consent of the governed. And so that's one of the reasons why I'm not in complete and abject despair.
There's a federal statute adopted in 1878, the Posse Comitatus Act, that says that the military can't be used for domestic law enforcement. Why is it called that? Why did it come into existence? Well, after the Civil War, during Reconstruction, there was military rule over the South. The former Southern states were divided into 5 territories, and a military general was put in charge of each, and citizens were recruited to help the military in enforcement of the law. And when police or the military would recruit individuals who were not police officers or military, they were called a posse comitatus. Well, after Reconstruction ends in 1877, and after the South is again represented in Congress, not surprisingly, one of the first things that they did was pass the Posse Comitatus Act. And it reflects a long tradition in the United States that we don't use the military for domestic law enforcement. There's very good reasons for this. Police are trained with regard to law enforcement. They're trained with regard to constitutional rights, even though they don't always follow them. They're trained with regard to being limited in the use of deadly force. The military is not trained to protect people's rights. The military is not trained to be restrained with regard to the use of deadly force. Rarely in history has the government ever used the military for domestic law enforcement. But there is an exception to the Posse Comitatus Act. That is the Insurrection Act. And the Insurrection Act was adopted in 1807, and it allows the president to call the military into domestic service, and it has to be that there is such a grave insurrection that the police aren't able to keep order, or such a violation of civil rights that there's no other way to protect it. Dwight Eisenhower used this authority to help desegregate the Little Rock public schools. Lyndon Johnson used it in 1965 to protect civil rights demonstrators in Selma, Alabama. But that was the last time it was invoked without the request of a governor. It is extraordinary that after a federal judge in Portland this weekend said that the use of the troops, the National Guard, violates the law, President Trump says, well, I'll just invoke the Insurrection Act. I think even if he invokes the Insurrection Act, hopefully the federal courts will say there isn't an insurrection going on. The requirements of the 1807 statute aren't met. And what's so frightening about this is there's no legal authority under the Constitution or any federal statute for martial law. But using the military in this way for domestic law enforcement in Los Angeles, in Washington, in Chicago, and in Portland seems such a large, frightening step towards martial law in this country.
In the red shirt on the aisle? Yes, you. Or purple shirt? Sorry, we can't see very. Yes, you.
Bright lights here.
Yes, you just touched your badge. Brown hair. No.
Okay.
Oh, sorry.
First, I want to thank you for all the expertise you're sharing with us, both enlightening and addressing in equal measure. I want to get back to the question about the university.
Obviously, that's a question to ask to now University of California President J.B. Milligan or Chancellor Rich Lyons here on the Berkeley campus, I'll tell you my impression, and it's an educated impression, is that I think that the university is afraid that if it would sue the Trump administration would retaliate by cutting off more federal funds. So they've made the choice better not to sue than to risk that. And they're not alone. Only Harvard has sued. That, I think, is the answer to the question. As you can tell from my remarks, I have a different perspective. It's that I think when the Trump administration wants to cut off funds, they're going to do so whether the university sues or not. Look at the cutoff of $584 million to UCLA. And I think the only way to succeed against a bully is fighting back. But we'll see. I think history will show us, was Harvard right in suing? Was Brown right, Columbia right in capitulating?
Sure. I
Well,
mean, we've
sure.
all been saying, speak out, write a letter, send an email to say, whatever your connection, retired faculty, members of the community, they need to hear that, because they think they are being good stewards of the University of California. I went to a town hall meeting where Rich Lyons said exactly that. He said, look, I am trying to protect you and the University of California. And I think what they need to hear is that they, by capitulating or by trying to hide under a rock, are failing to protect the values that the university stands for. Yes, I think Sarah McKenzie, I was talking to you beforehand. Yes, you. Susan, sorry, I knew it began with an S.
I think that last question was better to end with than mine. And I just want to really thank you for coming, and your international students are so important.
I think what we have right now is 6 very conservative justices who so far acted as a rubber stamp for the Trump administration, and 3 liberal justices who've written very powerful dissents, especially Justices Sonia Sotomayor and Ketanji Brown Jackson. I think that what might change it is if there's a point at which 2 of the 6 conservatives get afraid as well. Catherine and I were talking at dinner, and she said to me, I wonder what John Roberts feels as he sees the military going into Chicago and Portland. Is he afraid of what this means as we're afraid? So I think we have to find ways of communicating to the Supreme Court that they should be afraid. And maybe it's with things like op-eds, maybe it's with regard to rallies in the streets, maybe it's by putting pressure on members of Congress to speak out and those with influence. But I think if it's going to be from the Supreme Court to protect us, it's going to take at least 2 of the 6 conservative justices to stand up to President Trump. I'm hopeful that that might happen. We just haven't seen it yet. You can, though they won't.
So I think there was the comment about martial law, that yes, there was martial law declared in Hawaii, but the justification for that was that Hawaii was a war zone at the time because of the bombing at Pearl Harbor. It's extended far beyond when there was a risk in Hawaii. But I think one of the historical legacies of that is many people, including many Hawaii business interests, thought it was a big mistake. I think in terms of the shadow docket, the emergency docket, where there are all these unsigned orders, I think the more people criticize the courts deciding cases that way, important decisions where they are changing the law, overruling precedent, and not giving reasons for it, the more people talk about that delegitimizing delegitimizing the Supreme Court, the more they are likely to pare back their use of it. So I think, for example, last summer when the court had issued some rulings on the shadow docket staying lower court decisions without opinion, and then other lower courts ruled on related but distinct issues in different factual scenarios, and the Supreme Court stayed those, and there was separate opinion by Justice Kavanaugh sort of wagging his finger, or Justice Gorsuch, maybe both of them, wagging their finger at the lower court judges for defying the Supreme Court and saying, you can disagree with us, but you have to follow our rulings. There was, among the people who comment on the Supreme Court, there was a fair amount of bipartisan criticism of that, because if they haven't, first of all, they had never previously treated their unsigned orders and unreasoned orders as precedent that have to be followed. They're supposed to be just staying lower court decisions to allow the case to go forward. And I think once a justice has to write a separate opinion saying, you're not paying enough attention to us, you must follow what we say, they've undermined their own legitimacy, and they've admitted there's a problem. And they're smart, they know what's going on. And so what I would say is, the more people criticize their decision-making, not as the neutral exposition of legal principles and calling balls and strikes, as John Roberts said in his confirmation hearing, which is nonsense and he knows it, but it's a helpful myth that they like to tell about what they do. And the more people see it as just siding with the Trump administration without giving reasons, overruling established precedent without giving reasons, the more they undermine their own credibility. And that is something that they might be responsive to, perhaps, as much as the fear that somebody is going to blow up their summer house or shoot them in the street, where I think they think they're pretty insulated from that.
Thank you so much for having us tonight.